preliminary hearing. And the witness was not in the courtroom during the testimony of witnesses. So he can't testify about, just as you asked the question about conflicts between what the witnesses have said and what they told him. If you want to ask fact-specific questions of this witness with regard to his conversation with Mr. King without the conclusion, the court would, of course, allow that. It would be up to the jury to determine whether Mr. King testified differently to them than the statement made fact-specific to this witness.
So then we can ask the question regarding his familiarization with law enforcement, which is contrary to his original statement before the court.
My ruling is you can ask this witness whether any other witness that they interviewed gave fact-specific. You have to ask the question. Did you speak to Mr. King about such and such? What did he tell you? Then it'll be up to the jury without editorial comment to make a determination whether that testimony is different than the testimony that the witness said.
In other words, don't try to lead the question. Yes,
Right.
Yes. John, a further objection would be, of course, that for impeachment by an inconsistent statement, Mr. King had to be asked a specific question. So the state would object to Mr. Parsons asking this witness anything other than the exact question that Nick King was asked. My memory of the shushing of the dogs or the scaring away of the dogs was he was asked some general question in that regard, and Mr. King said, I don't recall, which wouldn't even be proper for impeachment. And I don't recall Mr. King being asked anything other than, do you know law enforcement? And his response being, I didn't then, but I know now. Mr. Chapman has not indicated in any kind of specific fashion that was the question that he asked Nick King. Whether about he knew law enforcement then or he knows them now, and in any event, these are all immaterial issues. Whether the sky was blue, whether the dandelions were in bloom, all of these are immaterial, Your Honor, we suggest.
Are you asking to call this witness in front of the jury?
Yes, sir.
Ask the jury to come back in, please. You're cautioned not to ask questions, though, about the other matters that you covered in this witness.
Yeah, may we approach, please?
Rather than send out the jury again, if Mr. Parsons' response could be soft enough for the jury not to hear, there was some kind of vague questioning about any kind of a background check or criminal history or something, to which Mr. Chapman said, I started a preliminary or did a something. And I don't think the foundation's been laid to ask him any questions in that regard at all. And I don't want to be put in a position of objecting once Mr. Parsons asked that which is clearly inadmissible about a background check.
I'm glad to provide the district attorney a copy of Mr. Chapman's notes. That's all I'm going off of. What?
I made a ruling specifically about the questions that could be asked, but that you covered with this witness, and only those type of questions.
Right.
In other words, I'm sustaining the objection about this other subject.
Regarding the...
For example, and perhaps this needs to be made an exhibit for identification purposes, but just glancing at the paper. It wasn't even addressed in the outside the court, the jury here, you know, outside the.
That's why I didn't bring it up, because
I suspect it is.
Nick King
Your Honor,
never
again-
said anything about it. That's why I didn't ask this man about. Nick King made the
Your
comment
Honor-
to him about me having a mental
Court
evaluation.
sustained the objection with regard to that.
I never asked Nick King on the stand. Did he say anything?
Sustained the objection with regard to that.
This particular witness, he is an investigator for the defendant for the sole purpose of the jury making a determination as to whether any of the sworn testimony that you may have heard earlier in the trial, whether any of those witnesses may or may not have made a statement contrary to that when asked the same specific question by someone else. So the evidence in the case is the testimony that you heard here today or yesterday by a witness. However, you have to judge the credibility of that. So whatever was said out of court is not the testimony or not the evidence of the case, but can be considered for the purpose of testing the credibility or truthfulness of anything said here in the courtroom. Again, it has to be the same type question that was asked of the witness, and then it's up to you to determine whether the response by the witness was different or not. So, and you're the judge of that.
Good evening. Please state your name for the record.
Clark Chapman,
And Mr. Chapman, where are you employed?
Eyewitness Investigations in Memphis, Tennessee.
And how long have you been there?
I've owned this company about 11 years.
And what is your function at this employment?
Private investigator.
And what type of investigations do you perform?
Usually legal investigations and mainly criminal matters.
And do you take all types of cases, or the low-level drug cases and thefts, or do you take the really, really high-end cases, the murders and the very serious?
A lot of violent crime cases, murder cases.
And were you in essence hired, authorized by the state to assist in doing investigative work in preparation for this trial for the defense?
Yes, we were appointed to this case.
And during your conversations with some of the state's witnesses, specifically Mr. Nick King, did you ask him about relations that he had or people that he knew that were in law enforcement in Tipton County?
Yes, I did.
And what was his response?
He said, I know Poncho and a lot of them guys. That was his statement.
A lot of them guys. Meaning sheriff's deputies?
I took it at that.
Okay. And if Nick King testified on this stand,
Objection, Your Honor.
Objection to be sustained.
do you have a copy of your notes
Yes, sir.
with you? Did you interview anyone other than Nick King?
No.
Did you attempt to interview other people?
Yes, we would call it a few.
Did you ask Mr. King about being informed he was under citizen's arrest?
He mentioned that several times in his statement.
Do you recall what he said regarding that?
Your Honor, objection to the form of the question. It has to be the same question that was given to Mr. King if it's being offered for any kind of impeachment purposes.
Objection to be sustained.
I guess the question asked Mr. King was he instructed that he was under citizen's arrest, and did he submit Did Mr. King acknowledge being told he was under citizen's arrest, and did he say whether he submitted?
He did acknowledge that you were trying to arrest, use a citizen's arrest. He did acknowledge that he didn't abide to what he was asked to do.
So he did not comply.
Not from what I understood.
And when you asked him about the citizen's arrest, did he make any other comment?
Objection, Your Honor.
Object to this statement.
Did he say citizen's arrest don't mean
Your Honor,
shiitake?
objection. He has to be asked, as Your Honor knows, Mr. Chapman has to be asked the same question previously asked of Mr. King by Mr. Parsons.
When Mr. King was asked if he was informed he was under arrest and asked what he did at that point, did he submit? What did he do? He responded. And the question was presented to Mr. King again by you in this manner. Is that correct? On page 2, 6 line up from the biggest part of the paragraph, 6 line up, is that where that question is asked and answered in your notes. On page 2 of 6, it says, starts with the word putting, where it starts off, I'm putting you under citizen's arrest, where the question was asked. He's making the statement. He's informing you as to what was said at the scene. Could you read that, please, for the jury?
I'm going to object. Mr. Parsons needs to ask Mr. Chapman what question he asked Mr. King to see if it's the same question previously asked of Mr. King by Mr. Parsons, to see if there's any discrepancy.
Again,
That's a proper procedure, Mr. Parsons, if you can do that, please.
earlier today I asked Mr. Chapman, did I not tell him he was under citizen's arrest? Did you ask him a similar question?
Yes.
Do you see in your notes that question?
Yes, he said that you were trying to put him under citizen's arrest.
Okay, and what does the next line say? Quote from him.
Objection, Your Honor.
It's part of King's response to this witness. It's in his report. Is he allowed to respond?
You need to ask him what question he asked and what the witness responded, so that the jury can make a determination whether the witness was asked while the statement a similar question, and whether the witness gave a similar or different response.
Right, that's what I'm trying to evoke, is the response that he has documented as to the question about, did Mr. Parsons tell you that you were under citizen's arrest? Did he tell you that? What was his response then, as opposed to what is his response today? What was Mr. King's response to the question again?
As to putting him under citizen's arrest, he said that you were trying to put him under citizen's arrest.
And did he say anything beyond that?
Yeah, he gave a full statement.
What's the sentence following that?
Well, there are several times he mentions it. I'm sorry if I'm not following it. It's my fault, I'm sure, but there's 2 sections here where he's mentioning putting him under citizen's arrest.
Okay, I'm sorry. May I please pass this up? This is a copy of the report. I want to see if we can verify if we've got this report. Well, make sure we got the same thing. We'll verify and make sure it's the same thing. That's an identical copy. If you'll flip over to the second page, you'll see where the question is relating to the asking of, were you informed that you were under citizen's arrest? There's an underlining of that caption. It's at the bottom of the big paragraph. Would you please read that caption?
I don't see that sentence where you're talking. I apologize.
May I approach? Do you see an underlined sentence?
You can ask him a question, ask him if he asked the witness that question, then what response the witness gave.
If you look at the sentence just before where it's about the inquiry as to, did Mr. Parsons say that you're under citizen's arrest?
Where he says citizen's arrest don't mean what you're talking about?
If you'll read it for the audience.
Well, this is where the underline here says, I said citizen's arrest don't mean shit unless you call the law first.
That's what Mr. King said.
Right.
That's what his response was.
That's correct.
Okay. That's what I wanted to have the jury hear, his viewpoint of.
All right, no editorial comments, please.
May I please have the document back? Question I asked him.
You ask him about the dogs, about at least 6 people flying around. I mean, they're no reason. Yeah, most of the time you speak a loud clapping noise, and they'll go away.
Okay. Did you ask Mr. King a question about the fact that he said he saw my dogs before, and did he respond as to what he would do and what the dogs would do?
He said he usually just shush them away, clap your hand.
Okay, on page 4 was where that question is asked.
Yeah, if I could hear the question, I hadn't heard the question, I'm sorry.
Earlier today, Nick King was asked, wasn't it a fact that he had told an investigator that
The editorial comment, please, just ask this question.
Ask the question.
Ask the question, this is the witness response.
Did you ask Mr. King, had he seen the dogs before and what he did?
Yes,
Did he say that you could clap your hands and they would run away?
that's correct. Yeah, I'd asked him at his father-in-law, actually, the actual statement was, asked how, had your father-in-law had trouble with the dogs before? And his statement was, yes, sir, the dogs had been loose numerous times. Yes, sir, and most of the time he made a loud clapping noise at them or something like that. They would go away.
Okay. So that was his statement to you that he had seen them before, and by virtue of clapping his hands, they would go away.
Right.
Okay. Nothing further. Nothing further at this time.
No question.
Who's next?
Anyway, then we're going to break at this time. It's very important on this break to remember the things that we've been over, and that is, please don't discuss the case with anyone, or don't discuss it among yourselves. Allow anyone to discuss it with you. You have to keep an open mind. You've heard all the proof, proceed to charge the law, and then retire to decide the case. Only then should you begin discussing the case. When you go home with your family, they're certainly curious about what you've been doing. It's perfectly okay to tell them that you're on the jury and that you'll be glad to discuss it with them after it's over, but that you're not at liberty to discuss it with your family members now. The reason for that is that in case they may have heard something about the case or some aspect of it, that it's only human nature for them wanting to discuss that with you, and you may get some information outside the courtroom that might influence you other than what you hear in the courtroom. You have to make your decision solely alone on testimony introduced here in the courtroom and not what somebody tells you outside. Can everyone do that? Can we come back about 9 o'clock Monday? Anybody have a problem with that? Thank you so much for bearing with us on this trial. I greatly appreciate your willingness to serve as a juror, and we'll see you Monday. Hope you have a good weekend. Breathe deep, breathe out, think about something. Thank you so much. All right, is anything else we need to take up tonight? If not, we stand in recess to Monday morning. 9 o'clock, please. 9 o'clock.
Yes, ma'am.
Bo, could you give me back your office, please?
You going to be with us Monday? Carol coming back.
I think that's terrible.
All right.
She asked me if I could come tomorrow.
Everybody's worried about me on Saturday. Actually, I have a juror or two that can't be here tomorrow.
I think I'm in some of this.
Are you going tomorrow? Well, it's 30 and
Judge Walker, I'm sorry, I have Mr. Gary Anderkin here with us today, and I just wanted to confirm if he would still be eligible as a witness, or
We need to go back on the record. You'll go back on the record, Jim?
Yes.
All right. Although we have recessed, the jury has been dismissed right after we recessed, but before I left the bench, Mr. Parsons, you had a question. I asked the court to go back on the record.
Thank you.
So that we can take a question, please.
Thank you. I wanted to confirm that we would be able to call Gary Anderkin. We did get the testimony from Lyle Jones, but I would like to hear the other side of the conversation he had with Mr. Gary Anderkin to confirm Mr. Gary Anderkin, who ultimately made the decision to ask to be withdrawn as he saw a conflict of interest. I would like to get to the heart and the root of that perceived conflict, because I believe that it is germane to this matter. It's material that shows that there is an underlying concern that something improper has occurred, because out of the due course of events, it's not uncommon for a prosecutor to ask for an increase in bond and so forth, but for that to perk up the attention and cause a public defender to seek to recuse himself, that implies that there's a possibility, at least as I think everybody would believe, that there's a real life possibility that this is a conspiracy to falsely charge me, and nothing more than a plan hatched by Mike Donovan and his assistant to take out retribution on me, citing the fact that he found out that I was having his assistant Neil Odom indicted, and as a way to get back at me, he was going to have me falsely charged, face a trial of this magnitude, have my bond increased to take money away from me to preserve my liberty, and then ultimately being forced to be arrested and go through the jail system again. And I think that Gary would be able to testify as to...
Well, here he is.
Are we going to call him now? Or hold him over to Monday?
If the purpose for calling Mr. Anderkin in front of the jury would be for the reasons that you have stated, the court's ruling would be the same with Mr. Anderkin as it was with Mr. Jones. That is, the events, whatever they were, July of 2008, when the grand jury returned an indictment in this case, but apparently did not return an indictment that was sought by Mr. Parsons against an assistant district attorney, is irrelevant to the issues that the jury has to decide today, other than whether or not the state can carry its burden beyond a reasonable doubt. The charges against you returned by the grand jury in July of 2008. The indictment was returned. You were given some 7-8 months or whatever length of time it was to attempt to hire an attorney that went through 2 trial settings. The matter was then again reset. The public defender was appointed to represent you. Mr. Anderkin had indicated that he had a conflict since a member of his staff was a possible witness. That member of his staff, Mr. Jones, was subpoenaed, and in fact, as a witness for trial, and I've heard his reported testimony. You've made a record on that, and I ruled that that testimony should not be presented to the jury because it concerns events in July of 2008 when Mr. Jones testified. He overheard a conversation about additional charges against you, bond being raised, and so forth, what his testimony was. So if Mr. Anderkin's testimony is going to concern the same subject matter, then the court again would rule that he is not to be a witness in front of the jury. If you would like to put Mr. Anderkin on since he's here and put down on the record what you anticipate telling him and his responses, then you're welcome to call him. You want to make a record?
For the record, I think that I am entitled to present all defenses available to me, and I think that denying the jury the ability to hear a possible defense denies me due process.
Well, this here's the defense. He's here.
Would you like to call the witness and put
Yes.
it on the record? Sir?
Yes.
Mr. Anderkin, if you don't mind, I guess that you didn't mind.
Come on.
Yes, please. I know you don't have anything else to do at 6:40 on a Friday night, so if you'll raise your right hand, you solemnly swear or affirm testimony you give on this cause with the truth, so help you God. I do. Have a seat, please.
Please state your name
Gary Anderkin.
and where are you employed, Mr. Anderkin?
I'm the public defender for the 25th Judicial District.
And you're the elected public defender, is that correct?
That's correct.
And in January of 2009, earlier this year, was your office appointed to represent me in this trial, in this case?
We were for a very short time.
Okay. And you were released because?
We had discussed with Judge Walker that we had a conflict of interest.
And what was the nature of that conflict of interest?
The conflict of interest was because Mr. Jones had overheard a conversation in the hallway, and there was a possibility that he would be called as a witness because of that conversation that he overheard.
What of that conversation would possibly cause him to be called as a witness?
There was a question about vindictive prosecution.
A question in Lyle Jones's mind?
Actually, it was there was 3 or 4 of us that discussed it within my office, and we all basically agreed that his testimony, if it were required, would his being a witness, if it were required, would exclude our office from representing you because of what he might be called on to say.
So you felt that the information he provided you rose to the level that there was question as to whether there was prosecutorial misconduct?
We weren't concerned so much about whether there was prosecutorial misconduct or vindictive prosecution, as the fact that Mr. Jones might be a witness. I think the rules basically say that if one person in the office has a conflict, then the office itself is, not in those words, but essentially, if one person in the office can't represent a defendant, then no one in the office can.
Have you researched those rules, Mr. Anderkin?
Well, when you say have I researched them, I've read the rules and the comments.
You've reviewed the rules regarding conflict of interest?
Yes, in that regard, yes. Regarding if someone in the office is disqualified, then all the attorneys are disqualified. I don't think that's an absolute. There may be some exceptions in the rule, but I don't think, we felt like the exceptions didn't apply. Or if they did, they may or may not. There was a question if they would or wouldn't.
But it's actually in the captions where the judges who make these ultimate rulings put their intent, where it clearly states that as long as the person in the firm isn't a party to the case, that the other members of the firm can carry on with the trial. Is that not the caption?
I don't remember. The last time I looked at the rule, Mr. Parsons, is the day that you and I talked about it. And I don't know how many months ago that was, 4, 5.
Do you recall me filing a motion to have your office to reappoint you as the legal counsel in this case?
If you served my office, I probably saw that, but no, I don't recall it.
Do you recall me coming to your office and having a conversation with you?
Oh, you came to my office and we talked probably for an hour and a half in detail. And I think I told you at that time that there was a question about whether we could represent you because of conflict. And when I say we talked in detail, I mean, I don't think we talked in detail about the facts of the case as much as just some options and that sort of thing.
And it was actually twice that I filed motions seeking the assistance of the public defender, and both were denied. Do you recall that?
I just recall that we were allowed to withdraw because we had a conflict of interest.
And that meeting that you had was an ex parte motion, an ex parte hearing with the judge in chambers, is that correct?
You were with me, except you didn't go in his chambers, that's correct.
That's right.
And I think basically what that discussion dealt with was I showed the judge the rule, and I'm sure he knew it anyway, but he looked at it for a few minutes or a minute or two, and I think at that point agreed that there was a conflict. And then I immediately told you that was the decision.
If you were in my shoes, would you have also wanted to call Lyle Jones as a witness to develop the possibility of vindictive prosecution in your defense as a reason for a defense?
I'm not in your shoes, Mr. Parsons.
If you were representing me, would you have advised me to pursue that potential defense?
I don't know that.
With the information that you had from Mr. Lyle Jones.
Here's the way I felt about your situation, if I may.
Yes.
You were the one that kind of insisted on using that, and we discussed that. And my feeling on it was that if you insisted on pursuing some kind of dismissal because of the indictment, because of vindictive prosecution, my feeling on that was you're the defendant, and I'm pretty much, if I was going to be your lawyer, I'm pretty much at your call to do what you want within reason. So if you had insisted on using that in some way, then I would have at least considered it very deeply, very seriously. And I'm not going to say that when everything was said and done that I would have done it, but I'm certainly not going to say that I wouldn't have done it.
Will you believe it's a responsible thing to take every opportunity to have charges dismissed if you have it at your disposal? Would
Well,
that
I
be a fair
mean,
statement?
there's two things that we would look at. Number one, what does the defendant want, and what's logical, and that would have had to be considered in light of the whole situation.
Was there anyone other than Lyle Jones who you're aware of that overheard the conversation between the district attorney and his assistant, Neil Odom, that day, who was there with Lyle Jones at that time?
Forgive me, I don't remember. It seems like there was two people in the hallway.
Do you have an investigator for your office?
I believe that's right. I believe maybe Mr. Huggins was in
Yes, sir.
the hallway, but I believe, if I may say this, that Mr. Huggins didn't hear any of that.
Okay.
If I recall what he told me. He may have been doing something else at the time.
If Mr. Huggins had made the statement to someone else that he'd heard this and then later became a sufferer of amnesia, would that have been uncommon for Mr. Huggins to not want to get involved?
I don't know.
Okay. Has this ever happened before? Mr. Huggins has had amnesia?
I've never been aware that Mr. Huggins had amnesia.
Okay.
I have a memory problem, but I don't think he does.
You one time had Mike Robbins working in your office, correct?
Years ago.
And prior to me seeking the assistance of the public defender for the second time, Mike Robbins was appointed as counsel, correct?
Best I know, yes.
And is it a fact that you informed me that after we spoke that there was an occasion where you obviously observed in your employ at that time Mr. Robbins berating a client, which subsequently he ceased to work with your office shortly thereafter?
I think we discussed maybe Mr. Robbins berating someone in a particular situation, but I don't think we discussed why he didn't work in my office.
Okay. But I believe it was your comment that was
Let me say this. You know, what we said as attorney and you were a client at that time,
right.
I don't feel like this is the right place to talk about it. I mean, if you want to ask questions, then you tell me to answer the questions and you release me from any liability.
Certainly.
And I'll answer all your questions.
Released from liability.
Okay. And as long as the court says we can talk about it.
The reason I'm asking this question, the only reason, is Your Honor has concluded that based on Michael Robbins' affidavit that he never came to court and testified or verified to against my objections, it's been made a part of this record, it's been spoken about that he was brought in and worked diligently on my behalf. And after speaking with Mr. Anderkin, it became my understanding that I wasn't the first person that Mr. Mike Robbins had threatened and tried to use the act of coercion to force them into pleading guilty to something that they weren't guilty of, as opposed to him diligently doing his job. And that became evident in the conversation with Mr. Anderkin. So that's the development of that
Well,
training.
you and I never talked about Mr. Robbins coercing somebody into doing something they didn't want to do.
No, but
we didn't talk about that.
But I explained to him that to you that he wanted me to plead guilty to something that I didn't do. Is that correct?
I can't remember.
But you remember telling me about him berating.
I remember you and I don't even know if the rating's the right situation or the right wording. I think we talked about that he had a conflict with a defendant on an occasion. I don't even remember the context of the discussion. But yes, we had a conversation dealing with Mr. Robbins' personality.
And was that personality the reason he no longer works at the public defender's office?
Your Honor, I know this is not a jury hearing, but it's apparent, I think, from the line of questioning, unless it takes a drastic turn, that Mr. Anderkin can't offer anything of help to a jury in this matter.
No, I felt it would be supportive in the judge's understanding that the delay of 3 months when Mike Robbins was on this case wasn't because he was diligently working, it was because he wasn't working and he was trying to force me into a plea deal. And there have been other cases where Mr. Robbins had been rude to other clients as well.
Well, if I could just say this about Mr. Robbins. Mr. Robbins and I, to tell you the truth about it, we don't really care for each other. But to tell you the truth about it, Mr. Robbins is a very diligent attorney. And I don't ever know of a situation where Mr. Robbins didn't do his job when he worked for me or any time after, when he didn't do his job in a responsible way. Now, I may not care for the man,
Right.
but I have to be honest about the fact that he's a good lawyer.
Okay.
And he is. And just so you know, I wrote a letter to the Oklahoma bar and told them the same thing.
Okay. What was the purpose of sending the letter to Oklahoma?
Because he was becoming licensed to practice in Oklahoma
Needed a recommendation.
by reciprocity.
Okay.
They actually sent a questionnaire.
But it's your testimony that you felt that there was some substantialness to this conversation that Lyle Jones overheard with District Attorney Mike Donovan and Neil Oldham, to the degree that you felt that it prompted you to ask for a recusal because it could ultimately end in, and I respect your honesty in letting me know that this existed, because I don't think a lot of attorneys would have done that. I think a lot of attorneys would have ignored it.
First of all, I didn't let you know. You already knew about the conversation before you and I ever talked. You're talking about the conversation in the hallway. I didn't tell you about that conversation. You did it when you came to my office.
Did Mike Robbins gather that information from you?
He didn't get it from me, and the best I know, he didn't get it from anybody in my office. I've asked everybody. I can't vouch for, I can vouch that they told me they didn't tell him. I don't know where he learned the information. He did not learn it from me, and you did not learn it from me. And the best I know, you didn't learn it from anybody in my office. Now, I don't know about Mike Robbins, but I asked everybody because I was aggravated if somebody told him about our conversations in our office. So I don't know where he got that information.
But the fact remains that you felt the information that Lyle Jones had witnessed rose to the level that it would be the responsible thing to do, the ethical thing to do, to ask to be recused as opposed to having him testify, which there was an indication overtly made that the potential is he would be called as a witness because there was obviously something that he heard or witnessed that potentially could have rose to the level of vindictive prosecution. Would that be correct?
Our concern was the fact that Mr. Jones might be a witness, and we just felt like we couldn't call him as a witness if he works in our office.
Right. And that was back from the very beginning when I asked to be appointed a public defender. That's when you had recused the first time, and then Mike Robbins was appointed.
I think that's right.
Yes, sir. Your Honor, I would move that this information be included as a defense that the jury be made aware of. I think it rises to the level of consideration of the jury, and I'd like to exercise that right to.
General, have any questions?
I have no questions.
Sir, you're released.
Thank you.
The court again sustains the state's objection with regard to this line of questioning with regard to Mr. Jones and Mr. Anderson in front of the jury. Anything else we need to take up tonight?
Your Honor, we have a motion for jury review that Your Honor was going to take up at some point. And I don't know if it's supposed to rain Saturday. They've already gone. It's kind of too late maybe, but I was just looking at the weather.
Like, we don't come back till Monday. We don't come back till Monday.
Right, that's what I was just looking at the weather. If Your Honor was going to approve that jury review, it would be preferable on a day that's sunny as opposed to rainy. That was the point I was going to make. Just looking at the calendar, Your Honor's schedule, and of course the weather.
Had the state raised an objection to the jury review, how would you propose to get the jury out there?
Individuals would just drive themselves of their own accord, meet here at the courthouse, and then carpool or follow each other down there. And then there is a large driveway at the property. They've got an airport hangar. I mean, so it's a hangar with a driveway that's about 15 foot wide, and it goes a couple hundred feet. And there's a house driveway there at Mr. Burnett's that's also about 400 feet. So I feel there'd be plenty of parking. Otherwise, if a bus is available in the county, maybe a school bus.
Now, besides the logistics problems, I assume, and I don't know, obviously, if Mr. Parsons is going to testify. He certainly indicated all along he's going to. I don't know if that means that we're going to have Mr. Parsons testifying and me therefore cross-examining him at the scene, and if each question requires a different location, if all the jurors and all the court personnel and the court reporter take her equipment over to the next one, that's the only way it would make any sense and be relevant, is if questions are directed at particular locations, which apparently are over a large area, with the additional concern, besides the logistics and moving people around and being able to hear outside and security, there's been all sorts of testimony about how dogs run freely here and wolf hybrids are often around, and I think there's security issues, there's logistic issues, and nothing to be gained other from what's been made available through exhibits of aerial photographs, Your Honor.
The problem with the jury review is that It's impossible for the view to be accurately included in the trial record. It might be reviewed on appeal. In addition, during the view, jurors could be exposed to information from people at the scene, could see a somewhat different scene than you've got 12 different individuals, might be looking at 12 different things, and the jury has to make a unanimous decision. You can't have jurors getting that information, one here, one there. There are provisions where jury views are permissible when it's very important to the case, for example, in condemnation cases. But the court believes that the risk of a jury view in this particular case greatly outweigh any benefit to the jurors of being trucked out and looked at the scene where this incident occurred, especially when you've had the exhibits that you've already had introduced into mine. So
Your Honor, the item that's in controversy is simply the lay of the land, the flatness of it. I would testify that the land was absolutely no higher from the lowest spot to the highest spot of 4 or 5 feet, and they've testified 50 feet, and he's saying he shot into the dirt. Well, I would testify that the shots were either ricocheting or he was shooting straight at me, and then also they could see the direction where he stated he pointed and shot towards the dogs at the pond, and see the wooded area and see where my wife was standing. They could easily see the impact of where I was standing, that I could visually see the whole thing. When I testify, it would be to the fact that I witnessed this man shooting at my dogs in the direction of my wife, putting her life in jeopardy, and then as the dog ran towards me, shots were coming towards me. I heard shots flying past my head, and I fired a warning shot at the ground, and he continued to fire. As my wife has already testified the shots that she's heard, I think the jury would have the ability at that point to see that, in fact, the state's witnesses did not testify truthfully regarding the elevation, and that it was reasonable that shots could have ricocheted and that shots could have been flying past me.
The request to have the jury carpool or be bused out to the scene can be denied for the reasons stated. Anything else to take up tonight?
What if they're allowed to drive their own vehicles?
I'm not going to rule on things multiple times. I've ruled with regard to that request. Is anything?
Well, it wasn't just about carpooling or buses. That was just an option. The motion was to allow them to go out and see the scene. And Your Honor just ruled about an effect of carpooling or a bus. The issue is not a carpooling or a bus. It's their right to be able to, am I right to allow them to see the...
You misunderstood my ruling. For the reasons I've stated in the record, the inherent problems with the jury view in a case like this greatly outweigh any potential benefit to the jury. That same information can be developed in front of the jury in other ways other than being bused and driven out to the scene. So the request for a jury view will be denied.
Nothing
Anything else we need to take up tonight?
No, Your Honor.
Stand in recess till 9 o'clock.
All right.